with a judge doing something outlandish and outrageous like Sullivan is doing. And by the way, the exact same D.C. Circuit turned around and immediately granted an emergency writ of mandamus to prevent Hillary Clinton from being deposed by Judicial Watch in her FOIA case.
Perfect segue. And it's an interesting thing in that case. Now, I forget the judges. It was a unanimous decision, I believe, in Clinton, right?
Yes, it was just a panel decision.
Okay, so here's one question. Okay, so for the Hillary Clinton, I'll summarize the facts, fill in the blanks if I've missed something. Judicial Watch filed a FOIA request back in 2014 about the Benghazi coverage, the political positions taken by politicians. They sought documentation, and by the judgment, it seemed that they were looking for written documentation, emails, not text messages, about the talking points that Susan Rice was going to be mentioning in her on-air coverage. It goes on for years, and this is what I presume you meant in terms of FOIA requests taking time. Judicial Watch filed the request. I think they filed the suit. It was years ago, right? It was 2016.
Yeah, well, it was before that, because what happened is Judicial Watch stumbled into the Hillary Clinton email scandal. They filed a FOIA suit, which is Freedom of Information Act, for those who wonder, to get the records about what internal communications took place in Benghazi. Once it came out that, for those who don't know this, the Benghazi Scandal, there's a great movie, 13 Hours, that documents it and details it. The SEAL team, the combined team, that military team, special ops team, ultimately wrote a book and disclosed the details of what happened. Basically, the U.S. abandoned its own ambassador to an Al-Qaeda raid that killed that ambassador and torched the embassy. It was right during the middle of the election in 2012 and happened in September, because it was on the eve of 9/11 that they did it. And despite the obviousness that that's what the source was, they instead blamed a small little filmmaker for making a film that upset radical Islamists, and that it was a spontaneous thing they had no reason to have notice of and no reason to have advanced knowledge of and no ability to defend. That guy, by the way, ended up getting railroaded by a federal judge simply for releasing that film, ended up going back to prison simply for releasing that film, ended up in a homeless clinic in California. That he was made the sacrificial lamb. The media covered up for it during the campaign. It came out after the campaign that the entire story was false, because the military people that were involved finally they lost their futures in the military by disclosing what happened, not disclosing anything confidential, disclosing what was not confidential, which was that it was an Al-Qaeda raid. There'd been advance warning of it. They were told to stand down. Everybody else was told to stand down, so they couldn't help people escape, couldn't protect the embassy. And Susan Rice, Hillary Clinton, and Barack Obama orchestrated a lie campaign to cover up the horror of what happened there and the tragedy of what happened there. From that, once Judicial Watch found out about it, they made a Freedom of Information Act request for all of the communications concerning it that you just detailed. And then they were stonewalled, so they filed suit. Midway through the suit, they found out that Hillary Clinton had a secret email server that was outside the state. That's the only reason why any of that ever got disclosed. It's why I always tell people to bring Freedom of Information Act claims, because you never know what you will stumble into. From that, there's been all kinds of delays at getting the relevant records. Finally, it was Judge Sullivan, same Judge Sullivan, who was so outraged by all the delay that he ordered Hillary Clinton to take a deposition. And she immediately said, this is outrageous, demanded a writ of mandamus. And by the way, writ of mandamuses almost never occur to stop discovery in a civil suit. You talk about having alternative remedies available.
Well, this is the number one question I had, and I was going to do this video yesterday, but I had too many fundamental questions. Is there no such thing as an interlocutory appeal or an appeal of an interlocutory decision in U.S. courts?
Only by discretion. So you can file an interlocutory appeal, but they can deny it. It's not an appeal as of right.
Okay.
So when you file a writ request, they have to rule on it.
Yeah, but do you not have to file the motion for permission to appeal and then get rejected before not having that as a viable recourse from an interlocutory being in the midst that is not a final decision? So you have a number of decisions during trial, just for everybody who's listening. Some of them might pertain to evidence. Some of them might pertain to discoveries. If it's not a final judgment, so it doesn't adjudicate on the ultimate issue, but you need to ask for permission to appeal because it does not. It's not a decision on the final issue. So I'm just saying, okay, they got permission to examine. If they didn't like that, make a motion for permission to appeal. And then if that gets dismissed, then there's no other recourse. Then you do a mandamus.
Well, but there's still plenty of recourses. She could have gone to the deposition, refused to answer. right? And then gone through the contempt proceedings, and then you have an automatic right of appeal through a contempt proceeding. So there are far more remedies available in the discovery. I have never seen a writ of mandamus issued to prevent a deposition of someone who's not an existing government official. It's never happened. So it's extraordinary. And yet they treat it like, oh, obviously this relief had to be, and just showed how political they are. There's no way to combine the decision they're about to issue in Flynn with the decision they just issued in Clinton. And they are so politically unaware, they don't realize the whole world sees this. And yes, people that are in their political camp are going to be with them. The problem is they are slowly, steadily destroying the integrity and the perception of impartiality of the American federal judiciary. And they're doing it to the one group of people that was the most law and order oriented audience in the world, which were American conservative Republicans. They're educating them, like in the past, they've educated the left, that our judicial system is highly partial, highly prejudicial, and highly partisan.
So actually, this is a good question I forgot to ask before. President Trump for Dummies. Is Jen Flynn still under gag order? Do you think that's why the judge is dragging this out till after the election? Is Flynn still?
He was never under a gag order.
Okay, so people might be confusing Stone with Flynn. So Flynn can talk if you want.
Yeah. My guess is that Sullivan has probably advised him not to necessarily, and I respect that. That is the typical choice. I would advise him to talk. Now, he's talked a little bit. He's done, but not about the case. But if I were in his shoes, I would have him doing some interviews.
So, and now just
that's my take.
To push back on something in the Hillary case. So the mandamus was issued after Hillary was in fact deposed. Hillary was deposed in the Judicial Watch lawsuit, right?
No, my understanding she wasn't. It was ordered that she be deposed, but she hadn't been deposed yet.
I thought she had been deposed a first time, and that this was a second deposition. I saw in the, maybe someone can correct us. This might be just a pure matter of fact. If anyone knows the answer, I thought she was deposed, and this was an extended deposition on other issues that hadn't been covered in the first deposition. But maybe I misread the decision.
That's possible. You may be right. I know she hadn't been deposed on this subject matter of this deposition. You may be right that in a prior part of the suit, she was deposed on a more limited.
That's what the judge said, that she had been deposed. It was as a result of her bad faith in not disclosing certain information or information that was discovered afterwards, that Lambert then concluded there was bad faith. So now we're going to expand the scope of subsequent depositions. And for my own benefit, how did it go from Sullivan to Lambert in the FOIA case, which are two different judges, if anybody doesn't know who those are?
I don't know.
Okay.
That's a short answer.
So, and now getting back to something you said earlier, which this was in the reasoning of the Court of Appeals decision to grant the mandamus to prevent the discovery. They said hold on, what did they say? There was two reasons. They said Hillary could show up, not be deposed, and then be held in criminal contempt, but not in a civil case, was one of the distinctions I think I remember reading.
That wouldn't make any sense. You can be held in contempt in a civil case, just like you can in any other case, and you have the right of appeal once a contempt has been issued or a sanction over a certain amount of money.
I'm gonna have they drew a distinction between civil contempt and criminal contempt.
Well, those are different things. That's true, but she couldn't be held in criminal contempt, but she could be held in civil contempt. So if anybody wants to see that, a federal civil case that I was tangentially involved in was the Joe Francis case in Florida, and they held him in civil contempt and then issued a sanction to try to punish him entirely. So, and that was all a civil case. He was not being held in contempt for a criminal case. So they have broad authority of contempt, civil or criminal. So while it's not a criminal contempt order, I mean, maybe they're saying a civil contempt order in certain contexts, depending on how the civil contempt order is issued, it's not always appealable. But that doesn't mean it wouldn't be. And so that's where, I mean, so that there's that remedy. There's also just that's one remedy. Also, other forms of evidentiary sanction are available, and things of that nature. So that's where, like, the idea that it would have no remedy for her to be deposed doesn't make sense to me. And then secondly, it's also just very rare in light of what they're going to do in Flynn. But independent of that, I thought the basis for her to be deposed was pretty clear. I mean, this is someone who hasn't answered any of these questions about government documents that are subject to FOIA, and she's failed to produce them for years. And so the idea that somehow she's supposed to be, it makes the FOIA law look empty if all you have to do as a political official is just not store them on a government server, and then never answer questions about it.
that was one of the things they said in the decision. Which so Gary Herman says no. The ruling said she did not have to be deposed. Okay, so I'll read through it anyhow. When I do a follow-up shorter vlog, I'll get clear on that question. They said that.
But you may be right now that you mentioned her being deposed before earlier in the case. That may be right.
I'm fairly certain she was, and that Lamberth came down on her because it was disclosed that she didn't communicate certain things. There were 39 discoverable documents that they did not communicate, and then when they discovered those, they said they hadn't complied with the initial undertaking. But what was I just about to say? The way the court of appeal, the panel gets around, they said, okay, well, yeah, you make a FOIA request. They just have to do a reasonable discovery, the reasonable search, and that satisfies their obligations. It's not. There was another act that they referenced which required a much more invasive search for the documents that were requested, but it was effectively just glossing over the bad faith, glossing over the non-compliance, and finding a way to get Clinton out of it, but not Huma. Was it Cheryl Mills or Huma Abedin? Who was the second one in that case?
It's either Cheryl Mills or I think it's Cheryl Mills.
And so they said Cheryl Mills was not a party to the suit, so she doesn't benefit from the mandamus because she has other recourse. That was what they said. It was that because Hillary was a party, she did not benefit from the ability to show up and be held in contempt without consequence, and that was not a viable consequence. And therefore, the mandamus could be issued against a party to the suit, but not against someone who wasn't a party to the suit. She has available recourse to show up and not answer the questions, as if to instruct her to show up and not answer the questions and potentially be held in contempt, and then just go to court and have the judge say, yeah, those requests for documents was excessive, and we're not going to allow them.
Exactly. There's evidentiary sanctions. There's a wide range of sanctions. I'm not getting their logic at all. So at least what I can say for sure is people object to depositions all the time. They either don't appear, they object when they're there, they engage in bad faith conduct when they're being deposed, and I have seen contempt be used against them repeatedly. I've seen evidentiary sanctions be used repeatedly. So the idea that the only remedy is mandamus at that stage did not make much sense. Normally they only do that when it's like the president or somebody, like where merely sitting for the deposition is an interference or intrusion into another branch of government. That's not. She's no longer a government official.
I mean, I'm gonna go through the excerpts from this decision because it wasn't just that. Again, foregone conclusion. Just Google the judges, left or right. You'll know where they're going to go with the decision based on the subject matter, unless it's politically neutral subject matter. So I knew where it was going. I knew the way they were talking disparagingly about Lamberth. I knew who he must have been appointed by or which party. Your experience with Lamberth, is he a competent judge? Does he have
never been before Lamberth?
Okay. No, so I mean, not knowing anything about him, they were just saying it basically effectively said his discretion, which is everything that the trial judge benefits from, his discretion was unreasonable. He came to ill-founded conclusions of bad faith. His orders were wide-reaching and broadened the scope of the FOIA application beyond what was initially requested, and therefore we're only left with mandamus 1 week after what happened in Flynn, or 2 weeks after what happened in Flynn. Question I was going to ask, I asked it sarcastically. Can not Lamberth? Can someone ask for a full hearing on Ball now? Is that?
Yeah, I'm sure Judicial Watch will. Tom Fitton will, and I'm sure he'll try to take it up to the Supremes. It's just tough because it's seen as sort of a smaller scale civil case. So it's very rare they grant en banc hearings. And once they granted it here, and you knew the Democratic profile of the court, you knew which way they were going, and their questioning reflected that. I've never seen a 4-hour oral argument before. And the other thing I kept thinking was, what a waste of 4 hours, because I was like, there wasn't a lot of informative, path-breaking.
Got nothing new out of it. They barely even touched on the disqualification issue, which was, as far as I was concerned, the more legally intriguing discussion in Flynn. We'll jump back to Flynn. Look, I have two theories. I think it was deliberate to bore people out of watching it and being able to effectively summarize it. Much in the same way, I looked over the NRA lawsuit, 163 pages. For everybody who doesn't know, the Attorney General versus New York NRA lawsuit to dissolve them, 163 pages, 680 paragraphs. I said, forget it. It's the easiest way to deter anybody from looking into it is to make it verbal written diarrhea so that nobody is going to take the time because they cannot take enough time to do it. It's crazy. I think the 4-hour hearing was just a distraction so that people would tune out and not actually get concise points and questions of law.
And the sad part is this was probably the most publicly viewed, publicly listened to DC Circuit en banc hearing in American history. And what they heard was not a endorsement of the American judicial process.
Yeah, it did not. Look, I'm not judgmental, and I don't judge others just to feel smarter about myself. It did not. I was not impressed, and it actually was sort of discouraging. It, like I said in my video, it sounded like a congressional hearing and not a judicial hearing. It was the same nonsense I would expect out of politicians, not out of judges. Okay, now so, Ghost Crusader says, I was unsubscribed to you and I did not unsub to you. That is very strange. You are by far not the only person to have told me this in recent memory, but YouTube is YouTube. The question I had, so in Canada, I don't think we have, I might be mistaken. I don't think we have this type of review. Court of Appeal renders a decision. I don't think there's this en banc review in Canada. I'm going to feel very stupid if there is, and I just didn't know about it.
I'm pretty sure it's probably not, because this is solely a function of the fact that we have so many judges. So in other words, for each circuit, we've got 10 to 12 active, another 5 to 6 senior. We appoint different ones by designation. So on any given appeal, you have a pool of 20 potential judges that are hearing a case. And so they created this en banc because of that reality. The circuit just comes from it used to be the U.S. Supreme Court justices, beginning of the country, rode circuit. Literally, that's where the circuit references. And so different Supreme Court justices would be responsible for different circuit reviews. And so we have, because of that historical precedent, the staff put certain things in motion that created this. Though as a whole, en banc decisions are extremely rare.
As in to say they rarely agree to hear.
Yes.
They rarely. It's not like a pre-appeal to the SCOTUS. This is very rarely. It's sort of like, as I would imagine, is it less rare, more rare? On par with asking a judge to review his decision, like we saw in Sandman.
The short answer is the same as the Second Amendment case this week out of the Ninth Circuit. Flynn got lucky with the original panel draw. He got 2 of the 3 Republican appointees that could have heard the case on the DC Circuit be assigned. And because the rest, normally when you see political cases like this get taken en banc, it's because the panel's political profile looks very different than the circuit as a whole.
Okay, very interesting. Now, I'm not going to read this one out loud because I don't want to trigger anything with the YouTube algorithm. Let's go conspiracy analysts for a minute. Just Scalia.
I honestly don't have any idea. I've heard the various theories, but I don't have any knowledge on that.
All right, and now we got Nate says en banc is needed to overrule 3-panel. Yeah. Well, that's the question. It's just like, from a Canadian perspective, Court of Appeal rules. I don't know that we have a bigger Court of Appeal to say, now look at the Court of Appeal, and if you guys say something different, then we go to the Supreme Court. Like, it's Superior or Court of Quebec, Appeal, Supreme. There's not this really internal review process like we see here.
And by the way, that's true for most of the states within the United States. So most of the states don't have an en banc process for their appellate courts.
Okay, and we got Tommy Stewart. I think I saw this question earlier, so sorry, but honest question from an increasingly disillusioned citizen. Is there anything the average American can do to put a stop to the corruption it's maddening to have to watch on a daily basis?
Be knowledgeable about it, expose it, and take what meaningful action you as an individual can do. And so it's the old answer, which is how do you deal with the problem of evil and the problem of evil people? Is you put more good and righteousness in the world.
I like that answer. I don't know my answer is just try to do as much good as possible, and especially just try to give knowledge and not bias or not misinformation. And by the way, we just hit over 5,000 people watching, so that's freaking amazing. So what do you think is going to happen in the Clinton cases? So bottom line, Hillary does not sit for the deposition on September 9th. Someone correct me, is it Cheryl Mills or is it Huma in that case? I think it's Cheryl Mills.
I almost guarantee it's probably Mills.
Okay, so they remanded it to the judge, which means what in the context of this particular decision?
It means that no further deposition of Hillary takes place, and they can only depose whom else is available to them and get what other discovery they can. I think long-term what it means is what's been true of the Clintons since as long as they've existed, is the Clintons don't face justice, and they won't hear.
You think it's going to go to anyone? Oh, so you do think they might petition for an en banc review?
Well, I think Fitton will go all the way to the Supreme Court, but I just don't think it will be heard.
Okay. What else do we have here? This might be a good segue for what is Barnes' interpretation of Fokker and 48A?
Yeah, I mean, my view is the whole reason for this, the best analogy I do give is the judiciary would be shocked if the executive branch could drag a judge before a grand jury every time they disagreed with his ruling on the theory that, well, maybe his motivations were corrupt. Maybe there was a bribe. That was the problematic aspect of that whole hypothetical. The reason why we have a separate system to deal with that is if a judge was actually bribed, there's an investigation after the case, so on and so forth. What you do not do is try to interfere with it, try to use that as leverage to threaten a judge with criminal investigation because you don't like his case. The same is true of the judiciary. They don't get to threaten the prosecutor in the executive branch when they don't like the outcome of a case by doing an impermissible invasive inquiry. And so that's what Rule 48A is there for. Rule 48A is there for that person. Fokker recognized that. I believe it was Siri. I'm giving this short version of his name.
Srinivasan.
Srinivasan. Man, there's no way I'm getting that right. Too many vowels. I used to my friend next door who was older than me when I was a little kid. I always called her Verne. It turned out her name was Renee the whole time. I found that out like when I was 25. But certain things can't do, so I don't try. But I believe he was the one who actually authored the Fokker decision. Whenever I see Fokker, I think of Meet the Fockers. So I have a hard time keeping a straight face on that name of that decision. But that in Rule 48A, its purpose was that prosecutors not to circumvent and abuse a defendant's rights. It's not meant to be anything beyond that. It was not a rule that was meant to somehow breach executive privilege and executive discretion about prosecutorial declination. There's no evidence for that whatsoever. And that it goes right against the constitutional separation of powers. And I do believe that if Siri's not careful in what decision he issues for this case in Flynn, the Supreme Court may take it. And if he gets the Supreme Court to slap him down, he can say bye-bye to his Supreme Court future, because a lot of political officials will remember this. So if he's smart, he'll do a compromise outcome that doesn't unduly agitate or upset the Flynn folks. But we'll see if he's as politically savvy as some people think he is.
All right, amazing. Forrest Stepper, we're going to be talking about Millie Millennial tonight, or Millie Weaver, as I now know. Sakake Onse says IIRC. What does IIRC mean again? I always forget that. Most of the circuit courts have finally been filled. District courts still have a bunch of vacancies. Think they could be filled before November 3rd?
Not likely. McConnell's trying to push through a bunch, but I don't think that will happen. But that doesn't mean they won't be pushed through by January 20th, even if the presidential election flips.
And Jason L says this is a good segue. Sorry, I just took it out. Last question. Real honest chances Snowden gets pardoned. They won't allow it, right?
If Trump is serious about, Trump has always said, he even said this at Liberty University, no less, which is a very, conservative Christian school. He said, never forget to pay back your enemies. And if he's serious about that, if he wants to deal a real response to deep state politics and power, then he will pardon Snowden and Assange. Here's what I think is going on. I think both the Durham investigation and the Trump's talks about pardoning Snowden are an attempt to create a détente with the deep state actors who tried to take him out in 2016 and 2017 and 2018 and 2019, that they should back off and not interfere in the 2020 election. Or if they do and he loses, he'll start pardoning everybody they hate. So and Durham will escalate and bring more indictments against more people.